Good morning, Judge Belcher.
Good morning.
Morning.
Why don't you have a seat, and when you're ready, you can give us your opening remarks.
Good morning. Justice Wiggins, members of the commission. As a young girl with a big dream from a small town, I remain humbled at this opportunity to present to you today. My childhood experiences sparked my interest in public service and birthed my dream to become a judge. Having been taught the most valuable lessons by my mother, the importance of my faith, the importance of an education, and the importance of treating others the way that I would want to be treated, I had the audacity to believe that I could make a difference in the lives of others. I chose to leave my small town and attend Howard University because I needed to understand who I was aside from being my mother's daughter. There, I gained the confidence needed to come to a state such as Iowa, to graduate from Drake University Law School, and to call Des Moines my home for the past 27 years. I have had an opportunity to make a difference in the lives of others by having an impact on the pursuit of justice for over 24 years, 15 years as a prosecutor, 9 years as a judge. I hold those who violate our laws accountable, fairly, yet firmly. I treat others the way that I want to be treated, with compassion, empathy, respect, and patience. And even though my rulings may not always be favorable, people walk away knowing and appreciating that they have had an opportunity to be heard. I have had an opportunity, and I believe I have made a difference in the lives of many children and the lives of the parents who appear before me in my specialty court, and the lives of the many students that I mentor, and my colleagues' understanding of why it is important for each of us to be trauma-informed and in the juvenile justice system by trying to address disparities. I believe I can continue to have an impact on the Iowa Court of Appeals, for which I believe I am uniquely qualified to serve. Both as a prosecutor and as a judge, I have maintained high-volume dockets. As a judge, last year alone, I wrote 50 termination of parental rights rulings, all while managing the highest volume caseload with over 400 cases a month. Aside from restricting one's freedom, I do not know a more impactful decision made by a jurist. As an appellate judge, I will have an opportunity to review the cases from the beginning, review them in the entirety, and make a ruling that is sound, decisive, and thoughtful, and is consistent with Iowa's Constitution, laws, and values. I would bring to this court years of trial and litigation experience, which I believe is important in the collaborative decision-making process. I also have a lot of knowledge in the different types of cases that are before the appellate court, and personal experience and viewpoint of those people who are most likely to be affected by those decisions. In paraphrasing Justice Thurgood Marshall, the mere access to the courthouse doors does not by itself guarantee a proper functioning of a judicial system. I believe the proper functioning of a judicial system depends upon judges who have real-life experiences and who are committed to having principled interpretations of the law. I have both the legal background and personal experiences, in addition to my reputation for having the work ethic, judicial temperament, and the ability to enter sound, thoughtful decisions that take into consideration the principle of our laws and Constitution. And I believe that would help us to provide access to justice and a fair and impartial appellate judiciary. I want to thank each of you again for your service on this commission, and again, I thank you for this opportunity. I ask for your vote of confidence in my nomination to the Iowa Court of Appeals.
Thank you, Judge Belcher. We're going to start the questioning with Mr. Gray.
Thank you. Judge Belcher, you obviously have judicial experience. Many of our candidates do, many do not. Do you think that judicial experience is essential to serving on the Iowa Court of Appeals?
Absolutely. I believe it's essential, and I believe because of my specific background in working with the types of cases that are appealed and working with the high volume of cases, that is essential for me to have the transition to the Court of Appeals.
Mr. Horbach?
No questions.
Ms. O'Brien?
Thank you. Judge, could you give us a little bit of insight into the work that you do on child in need of assistance cases, and then relate about how that might help you if you were appointed to the Court of Appeals?
I would preface that by saying that most of the people that I see suffer from some type of trauma, be it domestic violence, substance abuse, mental health, poverty, lack of income. I work on a daily basis by trying to make sure those parents have the services that are necessary to assist them so they can parent their children safely. The biggest example I can give you in terms of what I do currently and what I would do on the Court of Appeals are the termination of parental rights rulings. In each of those cases, I have to start from the beginning and review each of those decision points and make an assessment as to whether or not I believe a parent's rights should be terminated. On the Court of Appeals, I understand that most of my time, aside from 3 days, would be spent reviewing cases from the beginning to the end, looking at the different decision points, even though those decisions are made by someone other than myself, and being able to apply the laws and the Constitution and the rules to the facts to determine a sound and thoughtful decision.
Ms. Roberts? Ms. Conover?
To follow up on Ms. O'Brien's question, what is it about those child in need of assistance proceedings that sometimes unfortunately lead to termination of parental rights rulings that you find most challenging in your current position?
Most challenging is not being able to give the parents as much time as they need, because I have to determine what's best for the child. And most times, parents need more time to address those issues that I mentioned, substance abuse and domestic violence and mental health issues. They need more time than 6 months, or they need more time than a year. But based on the statute, I have to make sure the child have what we call permanency. So the child has an idea of where the child is going to be permanently. So the most difficult part is not being able to afford the parents some additional time, which they need, but they cannot have under the law.
Mr. Bloom?
No questions, thank you.
Mr. Goodman?
Thank you, Honor. Judge Belcher, thank you for your application. You've got a very heavy docket in your current position, and the docket on the Court of Appeals will be very heavy, and one of the key ways to addressing that is decisiveness. Could you give us two of the best examples, one as a prosecutor and one as an associate district court judge, where you really grappled with a decision and had to make that decision anyway, even though it was most difficult for you?
I'll start with, as a prosecutor, I mentioned a case in my application regarding trespass. And while trespass was a simple offense, it required a standard for the state to meet that had not been previously imposed. And I knew it was important for me to impose that standard and that statute, apply that statute to the case law, even though in the past it had not been applied. And even though it was a high-profile individual, there was a lot of media attention, I made sure I followed the law and made sure I held the state accountable to the standard that was required from the state. As a judge, I think the most difficult termination cases are those that involve mental health illnesses as opposed to substance abuse. Substance abuse is pretty much kind of black and white. A parent can either provide a dirty drug screen or a positive drug screen, or they can get the help and assistance that they need. But when I look at cases that involve mental health services, the hope would be that there would be a services available that we can wrap around the family so that the family could be in a position to take care of the child. But unfortunately, many of those parents struggle with taking care of themselves and meeting their own needs, and likewise, they are unable to take care of the needs of their children.
Ms. Diekman?
Thank you. Judge, in addition to your busy regular docket, I see that you were asked to preside over the Polk County Family Treatment Court. I'd like you to explain that to us and whether you think that that was a valuable experience.
It is a valuable experience. My treatment court is a collaborative court. We have a team of providers who meet together to try to make sure we're providing the necessary services to the families. Unlike other cases, these families come before me on a weekly basis. A lot can happen in a week. So with the weekly accountability, both to the court, with other parents who are struggling with addiction and may have had their children removed, it gives them additional oversight and encouragement by having interaction with the court. So the hope is, and the best practice shows, that those parents who participate in family treatment court and have that routine accountability and interaction with the court, they do better in terms of being able to have their children reunified on a quicker basis, and the hope is they will not find themselves back involved with the court system.
If I could follow up on that, do you know whether or not that specialty court is statewide or just in Polk County?
It is statewide. Not every county have one. I think there may be 9 or 11 currently in the state of Iowa.
Thank you.
Ms. Sinclair?
No.
Mr. Sukup?
Good morning.
Good morning.
Have you had any recent cases make their way up to the appeals court?
I don't believe it was a recent case. I do recall one case whereby I talk about permanency. That's when the court needs to determine whether the child's going to be permanently either 6 months, depending on the age of the child, or a year. That was a case some years ago when I had decided that I believed the child was able to be returned to the parent's care. And the matter was appealed, and the appellate court indicated the court could have given the parents another 6 months to be prepared to have the child returned, but based on the facts and the evidence, the court did not believe that the child could be returned at that time.
Thank you.
Mr. Bevel?
How long have you had the specialty court?
I've had a specialty court for about 6 years.
Thank you.
Ms. Law?
No questions.
Mr. Diaz?
Couple of questions. One has to do with the fit. If we're going to have, looking at judges, is it a better fit if you're coming from a district associate judge or from a district court position?
I would say it's a better fit coming from a district associate judge position for 2 reasons. One, because of the volume that I'm used to working with and handling a high docket or caseload. And 2, because of the vast variety of cases that I have experience in working in. So for the variety of cases and the type of cases that will come before the Court of Appeals, in addition to being able to manage a high volume caseload.
And then the second question has to do with this 6 months, 1 year. Could you explain it? And then has anyone challenged the constitutionality of placing a time limit on that?
I'm not aware of someone challenging the constitutionality of the time limit. If the child is 3 or under, we can determine permanency within 6 months because of the age of the child. If the child is over 3, then we have 1 year to determine permanency.
From what point?
From the time the child is removed from the parent's care.
So if today somebody removes a child and it's under 3, you must make a decision on permanent placement within 6 months?
I can, I'm not required to, but I have to give a year if the child is over 3. If the child is 3 or under, I can proceed with permanency. And most times that's a petition brought before the court by the county attorney asking that the court determine permanency at a sooner time rather than a later time,
And you
according
have
to
a certain
statute.
amount of discretion?
Yes,
All right, thank you.
you're welcome.
Mr. Berger? Ms. Bowden?
No questions.
Ms. Pearson?
No questions.
I have a question. Mr. Berger told me he took you to the grain, you met him at the grain bin or something?
Yes.
Went out a little early, she got there a little early. And
Yes. I had a beautiful tour of his big grain facility.
That's right, we sat and visited for a couple hours.
We did.
She experienced some mud roads first time.
Absolutely.
She got her back to telling them all in good shape.
Thank you. He did.
Following Mr. Diaz's question, 6 months and 12 sorry, 6 months and a year doesn't seem like a long time, but the child is usually in juvenile court for an extended period of time before that, before the termination petition is filed. So it's not like they file it and 6 months later you make a decision. Can you explain that, the way
Yes.
that works?
The
At least
first-
when I read the cases, that's what it looks like.
The first time the department gets involved, the child comes before the court. If there needs to be a removal, then there's a removal. And then there are timeframes with which, after the child is removed from the parent's care, if the child is 3 or under, then we have to proceed with permanency. There are a number of permanency options. One of the options is termination, but there are other options to have the child placed with a non-custodial parent. The child can be placed with a suitable other person. The parents can have an opportunity for 6 more months if they're working toward reunification, they're complying with the services to have the child returned to their care. But in those instances where the parents are unable to demonstrate that, then the option could be termination of parental rights. But the cases are usually before the court if the child is 3 or older, at least a year before we get to termination, and sometimes after that. Because if we've gotten to permanency and the court has granted a 6-month extension, then the child has been out of the home for a year and 6 months. But the hope and the goal is to make sure we are reunifying children to safe parents and providing them with the necessary services to ensure that.
And I understand the goal is to try to get them back to the parents, and if that doesn't work, the last ditch effort in the state under the law is to terminate, is that right?
That's correct.
I don't have any further questions. Does anybody else have any follow-up questions or anything? Okay, Mr. Horbach, can you beat the grain bin experience?
No, we met at Hy-Vee.
Yes.
I apologize for rising the second time.
No, you can, that's fine.
I just want to make a statement. You're very passionate about what you do, and all your letters of recommendation reflect that. So I'm trying, in a simple way, and this is very philosophical, you are actually overlooking the situation and you are managing the process. And this process is parents over a child, back and forth, what is proper, what is not proper, did they violate that process? Do you think, because I do, that environment allows you to use those same type of skills and abilities in the Court of Appeals, where you are evaluating process? You're not evaluating guilt, innocent, evidence, law. You're actually in the middle on the process. Do you think that those two are swimming in the same lane?
I would certainly agree with that, because it gives me an opportunity to look again at the cases that are appealed, and a lot of cases, overwhelming majority of the cases are child in need of assistance cases or termination of parental rights cases. So it gives me an opportunity to look at the process and make sure the standards that are met for each type of case is met, and then make a decisive, sound decision.
Thank you. Thank you, Justice.
Any other questions at all? Seeing none, we thank you for coming in this morning and wish you the best of luck.
Thank you.
Thank you.
Thank you.